that these discussions actually reflect real problematics. Because I want to acknowledge that the defense of these women's spaces, the defense of these significant conquests, is seen by my mandate also as fundamental. But I'm worried that a number of these measures might be fed by significant preconceptions and are not fed by evidence bases. For example, I mentioned the participation of trans women in sports. It is very often the case that when you interrogate the political actors that are involved in the preparation of such legislation, they will not be able to cite one example of trans women taking the place of, or in a way limiting the benefits of inclusion in sports for women. We recently heard, for example, the case of a trans athlete who has qualified to compete in the Olympics. And this, of course, has captured significantly the public imagination. But I would call attention to the fact that it's one person in a number of athletes that are usually in the thousands. And so the question is to what extent this is a problematic that represents a displacement, or it's a problematic that in the manner that is addressed actually perpetuates transphobia. And this is what I know to be the culture wars around this issue, and one that requires significant care to ensure that approaches are evidence-based and free from stigma and preconceptions.
Thank you. I can't. Yes, we've got Robin again. Go ahead, Robin.
Yes, thank you. Yes, you mentioned the case of the weightlifter from New Zealand, and it's I believe that she's the first trans Olympian to be selected. That will mean that a lot of sports governing bodies will have not had to come across this issue before. How can they best approach these sorts of issues, given that it might be the first time that they've had to come across these decisions? Thank you.
Thank you. I believe effectively that it is the first time in history that an openly trans person has qualified for the Olympics. As might be immediately evident to a number of you, that doesn't necessarily mean that it's the first trans person, given the fact that invisibility and opacity around gender identity has been the rule throughout history. It's hard to know whether this is the first case, but it is the first case of an openly trans person qualifying for the Olympics. There are tests that are now very much under consideration and adoption by the International Olympic Committee, and that relate to levels of testosterone in order to make a determination as to the ability of individuals to participate in sports. It's not a subject matter in which a complete decision or in which decisions have reached a level of finality, because I believe that there's a number of ethical, scientific, legal and political issues to be considered. But I believe that, that at the moment that is considered to be the most objective and the most science-based way to determine participation. Having said that, you do mention, and I agree that this is an issue that requires careful consideration by different bodies. The answer always lies in ensuring the participation of communities, persons, and populations that will be impacted by the decision. One of the consistent recommendations made by my mandate in relation to the design of public policy, and I would also include integration in sports in relation to this, is that public policy should be designed on the basis of evidence. It should also be designed with the participation of different communities and populations so that there is an understanding of the manner in which the policy will impact and the manner in which it will unfold. When it concerns populations that have been historically subjected to discrimination, there is an immense amount of things that we don't know about their dynamics of life and the way that public policy affects them. And therefore, participation is an essential element in the design of policies.
We have a question from Nick Cumming-Bruce from the New York Times.
Yeah, good afternoon. Thanks for taking the question. It's a very general question, but the justification given by states in Africa and perhaps parts of the Middle East for discriminatory legislation against gays particularly has been, essentially one of cultural defense. And my question is, does that have any foundation or defense or protection in human rights law?
Thank you very much for that question. In fact, as of today, 69 countries criminalize homosexuality or some forms of gender identity, which means that as of today, 2,000 million people live in criminalized environments. My mandate has carried out analysis in this relation of the human rights framework, both in relation to the historical development of right to privacy and more recently the connection of criminalization with breaches to the right of persons to live free from violence and discrimination and to live in freedom and equality, which is the fundamental conclusion of the international human rights law framework. So my mandate has provided abundant evidence that has complemented the findings of the United Nations High Commissioner for Human Rights, along with other global human rights bodies, inter-American system, European system, to the effect that there is no justification under international human rights law for maintaining criminalizing legislation in relation to sexual orientation or gender identity. The political is, of course, sometimes not necessarily the same as the legal, and I am in dialogue with a number of states that maintain criminalization and that give a number of explanations as to the reason why they're not tackling it. One line of argumentation says that it's not necessarily applied in practice, or at least is not applied very often. I recognize that this is the situation in certain countries, particularly in the English-speaking Caribbean. However, my work has produced abundant evidence to the effect that discriminalizing provisions, even when they are not applied, they create a context that is hostile to the existence of LGBT persons and that is also conducive to blackmail and to significant violence affecting the everyday lives of these persons. A second line of argumentation is that this legislation is actually reflective of traditional or ancestral mores. In reality, this line of argumentation does not resist the social, cultural, and anthropological analysis. In many cases, this legislation was implemented as a result of colonial processes of juxtaposition of colonial law to the local system. Finally, a number of countries that defend criminalization are basically going to the argument that it's reflective that homosexuality or lesbianism or some forms of gender identity are reflective of antisocial behavior, pathological behavior, and of course this is very much contrary to the basic values of dignity and the inherent right of LGBT persons to live free from violence and discrimination. In conclusion, I believe that there is an abundant body of work in international human rights law that allows us to conclude that there is no plausible justification to maintaining criminalizing provisions. And this is why my mandate has issued a global call for a world free of criminalization by 2030, which, as I have said today to the Human Rights Council of the United Nations, I hope it will become a common objective of a significant coalition of state and non-state actors because, as I said, it affects an enormous amount of individuals around the world every day. Thank you.
We have Nick Cumming-Bruce again.
Just to follow up on that, then, have you managed to convert any governments to this position?
I should say that I'm not in the business of conversion, but let's say that hopefully I'm in the business of persuasion. And given that that is the case, I will note that during the time that the mandate has existed, there has been a number of incredibly meaningful measures adopted to this respect. Now, I will not claim the merit for the extraordinary decision of the Supreme Court of India, which, with the stroke of a number of pens, actually took over 1 billion persons from an environment of criminalization to one that is not. I will also not claim sole merit, let's say, for the decisions in Botswana or in Trinidad and Tobago or in Belize or the process of decriminalization in Mozambique or Angola. But these are all processes that have happened as the result of the concerted action of a significant number of stakeholders in international diplomacy, in justice bodies, in the legal construction of theories that have been adopted by all of these judicial and public policy decisions, and that I believe are reflective of the way in which international politics, international law, and dialogue actually achieve significant results in connection to this. When I presented my first report to the Human Rights Council, I actually gave the Council the information that 3,000 million persons were living in criminalized environments, and we're down to 2,000 million persons. So hopefully it will be in the foreseeable future that we will see a world free of criminalization if more of these extraordinary processes can be put forward. Some of you will know that I just had the privilege of concluding a country visit to Tunisia, which is a country in which criminalization still exists. And it was only last Friday that I was giving a press conference in Tunis, where I was mentioning very much my hope that during the process of follow-up of my findings in relation to the country visit, we could engage in the debate and the dialogue around these criminalizing provisions that are still maintained in Tunisia as in 68 other countries.
I don't see any more questions. We can just wait just a couple of seconds to see if there's anything else. Ah, sorry, Stephanie in the room.
Thanks. I just wondered, turning to the United States, there's been a ruling last week in favor of a Catholic agency that it had to do with putting children in, refusing to put children in foster care with that organization because it barred same-sex couples from applying to become foster parents. Do you have concerns that, you know, the current composition of that court might be handing down, you know, what would the effects be of that sort of ruling? And do you have concerns about their it was a 9-0 ruling. Do you have concerns about how they are coming down on the side of those sort of cases?
One of the approaches of the mandate is that I do not engage with hypotheticals in relation to future actions of the state, be it in terms of judicial decisions or public policy or legislation. I am aware of a significant number of judicial controversy in the United States and, in fact, in other countries around the world around this very specific relationship of private providers of services that, in fact, are an extension of the state's function. In this case, as you say, it's the screening of foster families. And the arguments around the importance of listening to the possibility of agencies that work from a faith-based perspective to actually work within the realm of their conviction. So I believe that that is the framing of that decision, and I believe that in this particular case, the legal precedent that had been established in Smith was not, in fact, overturned, but that the agency was allowed to continue working within this frame. I have not engaged with the particular issue. It's a rule that I will need to engage with the concerned state if I were to issue an opinion around the matter, and I haven't done that, at least I haven't done it yet. But I can tell you this. It is a fundamental part of my work to actually understand and try to elaborate and offer narratives about how the right to freedom of religion and belief is not contrary to a right to live free from violence and discrimination based on sexual orientation and gender identity. And I would draw your attention to the statement that I had the honor to co-author with my colleague, the Special Rapporteur on Freedom of Religion and Belief, Ahmed Shahid, and in which I was accompanied by 115 human rights experts from the United Nations, the European system, and the Inter-American system. And this statement actually aims at clarifying that there is not such contradiction between the ability of persons and groups of persons to hold religious belief and the respect that it's owed to persons to a life free of discrimination. The confines of these elements are usually given by the respect of the rights of others and the internal and external dimensions of right to freedom of religion and belief. I will continue this line of inquiry and I intend to issue a report on religion and sexual orientation and gender identity in the year of 2022. It will be one of the reports that I present to the General Assembly and to the Human Rights Council.
Thank you. I don't see any more questions. I think we can call it a day. Thank you. Thank you, journalists.